Still ahead, Jackson's cross-examination of Hermann Goering continues.
But this witness, seems to me, is adopting and has adopted in the dock and in the stand an arrogant and contemptuous attitude toward this tribunal.
Coming up in our look at the Nuremberg Trial. Welcome back. As Robert Jackson continues his cross-examination of Hermann Goering, Goering talks about his relationship with Adolf Hitler, and he continues his discourse on German patriotism and the majesty of the Nazi Fuhrer. Goering talks of the shame Germans felt in his country over the Treaty of Versailles, which ended World War I by severely restricting German rearmament.
When you met Hitler, as I understand your testimony, you found a man with a serious and definite aim, as you said, in that he was not content with the defeat of Germany in the previous war and was not content with the Versailles Treaty.
Ich glaube, Sie haben mich da nicht richtig verstanden, denn genau so habe ich...
I think you did not quite understand me correctly here. I did not put it that way at all. I stated that it had struck me that Hitler had very definite views of the impotency of protest. Secondly, that he was of the opinion that Germany must be freed from the dictate of Versailles. It was not only Adolf Hitler. Every German, every patriotic German had the same feelings. And I, being an ardent patriot, bitterly felt the shame of the dictate of Versailles, and I allied myself with the man about whom I felt that he perceived most clearly the consequences of this dictate, and that probably he was the man who would find the ways and means to set it aside. All the other talk in the party about Versailles was, pardon the expression, mere twaddle.
And it was for that end that you and all of the other persons who became members of the Nazi Party gave to Hitler all power to make decisions for them and agreed in their oath of office to give him obedience.
Ich habe nach einer gewissen Zeit, als ich mehr Einblick in die...
After a certain period of time, when I had acquired more insight into the Führer's personality, I gave him my hand and said, I unite my fate with yours for better or for worse. I dedicate myself to you in good times and bad, even unto death. I really meant it, and still do.
Now I call your attention to the minutes of the 10th meeting of the Working Committee of the Reich Defense Council. Do you find this? The demilitarized zone requires special treatment. In his speech of 21/5/35 and other utterances, the Führer and Reichschancellor has stated that the stipulations of the Versailles Treaty and the Locarno Pact
beachtet werden müssen.
Regarding the demilitarized zone are being observed. Do you find that?
Jawohl.
And you also find these preparations include, in particular, the following. A and B are not important to my present question. C, preparation for the liberation of the Rhine.
Oh nein, hier irren Sie sich außerordentlich.
Oh no, here you have made a great mistake. The original phrase, and this alone is the point in question, is C, preparation for the clearing of the Rhine. It is a purely technical preparation that has nothing at all to do with the liberation of the Rhineland. Those were general preparations for mobilization, such as every country makes, and not for the purpose of the occupation of the Rhineland.
But were of a character which had to be kept entirely secret from foreign powers.
Ich glaube, mich nicht zu erinnern.
I do not think I can recall reading beforehand the publication of the mobilization preparations of the United States.
Now, here we see perhaps a bit of the Supreme Court justice in Robert Jackson failing him as the cross-examiner, because Lee Bailey, I believe if you were asking these questions and you were getting the self-serving, non-responsive answers, you would have turned to the tribunal and made him straighten up.
Well, to a degree. Unfortunately, the questions here were not very good. They're too broad. You know, the cross-examiner's weapon is not a shotgun. It's a rifle. You point right at the subject, keep the answer tight. But if you ask a broad question, you can't shut the witness up. And here, Goering is just prattling on, giving his political speech. He shouldn't even be in this area. He should be in the specific acts of misconduct and not the political differences.
Well, and not only that, but when he goes back to the Treaty of Versailles, there was a considerable body of opinion in the United States that the Treaty of Versailles was too harsh on the Germans after World War I. Now, it doesn't mean that they sympathize with Hitler's solution for that, but I'm not sure that that's taking him anywhere to criticize him for not liking the Treaty of Versailles.
Well, that's right. This is not a case about breach of the treaty. This is a case about the most cruel treatment of human beings ever recorded.
Well, they got around to that, but not there initially. We're going to take a break, and then we'll be back with more of Justice Jackson's cross-examination of Goering. It was a confrontation which many thought Goering won.
He really permitted Goering to read into the record of the trial an entire New Testament of Nazism. Goering really went on for almost 3 days saying, here's how in the future you can avoid the mistakes we made and achieve the same objectives we were after.
Robert Jackson is an Associate Justice of the U.S. Supreme Court and a superb orator. He does not do well against Hermann Goering, the first defendant to be cross-examined at Nuremberg. Goering appears to enjoy himself as he runs away with his testimony. Apparently somewhat flustered and embarrassed by his poor showing against Goering, Jackson becomes testy and then runs into trouble with the Chief Judge, Sir Geoffrey Lawrence of Great Britain. As day 3 of the cross-examination begins, Jackson comes back to a caustic remark Goering had made the night before.
The last question which I asked last night, referring to the mobilization preparations for the Rhineland, as shown by the official transcript, was this. But of a character which had to be kept entirely secret from foreign powers. The answer was, I do not believe I can recall the publication of the preparations of the United States for mobilization. Now, representing the United States of America, I am confronted with these choices: to ignore that remark and allow it to stand for people who do not understand our system, or to develop at considerable expense of time its falsity, or to answer it in rebuttal. The difficulty arises from this, Your Honor, that if the witness is permitted to volunteer statements and cross-examination, there is no opportunity to make objection until they are placed in the record. I respectfully submit that if the ruling of the tribunal that the defendant may volunteer questions of this kind is to prevail, the control of these proceedings is put in the hands of this defendant, and the United States is substantially denied its right of cross-examination under the Charter, because cross-examination cannot be effective under this kind of procedure.
Are you submitting to the tribunal that the witness has got to answer every question yes or no, and wait until he's re-examined for the purpose of making any explanation at all?
I think that is the rule of cross-examination in ordinary circumstances, that a witness, if the question admits it, must answer. And if the explanation if there are relevant explanations. Now, let me come back to the specific problem I have right here this morning. Here is an answer given which the tribunal now rules is irrelevant.
But we had no opportunity to object to it. The tribunal had no opportunity to rule upon it. Had counsel asked, did you ever hear of the United States publishing its statements of mobilization? Of course, we would have objected. The difficulty is that the tribunal loses control of these proceedings. If the defendant, in a case of this kind, where we all know propaganda is one of the purposes of the defendants, is permitted to put his propaganda in, and then we have to meet it afterwards. I really feel that the United States is deprived of the opportunity of effective cross-examination if this is the procedure.
Surely it's making too much of a sentence which the witness has said about whether the United States makes its mobilization orders public or not. Surely that's not a matter of any very great importance.
Let me agree with Your Honor at once.
Every country keeps certain things secret. Surely it would be much wiser to ignore a statement of that sort. But as to the general rule, the tribunal will now consider the matter. I have already laid down what I believe to be the rule, and I think with the assent of the tribunal, but I will ascertain.
Let me say that I agree with Your Honor that as far as the United States is concerned, we're not worried about anything this witness can say about us. We expected plenty. The point is, do we answer these things or do we leave them? The point is the control of this trial. And it does seem to me that this is the beginning of this trial getting out of hand, if I may say so, if we do not have control of this situation. I trust the tribunal will pardon my earnestness in presenting this. I think it's a very vital thing.
So I've never heard it suggested that the counsel for the prosecution had got to answer every irrelevant observation which is made in cross-examination.
That would be true in a private litigation. But I trust the court is not unaware that outside of this courtroom is a great social question of the revival of Nazism, and that one of the purposes here of the defendant Goering, I think he'd be the first to admit, is to revive and perpetuate it by propaganda from this trial table if possible.
Mr. Justice Jackson, the tribunal considers that the rule which it has laid down is the only possible rule, and that the witness must be confined strictly to answering the question directly where the question admits of a direct answer, and that he must not make his explanation before he gives a direct answer. But after having given a direct answer to any question which admits of a direct answer, he may make a short explanation, and that he is not to be confined simply to making direct answers, yes or no, and leading the explanation until his counsel puts it to him in a re-examination. As to this particular observation of the defendant ought not to have referred to the United States, but it is a matter which I think you might well ignore.
I shall bow to the ruling, of course.
And so we ask our guest commentator, F. Lee Bailey, who's right, the court or Justice Jackson?
Jackson's wrong on this one. First of all, you've got a man on trial for what will surely be the loss of his life, and he knows it. It brings to mind an old anecdote where a testifying defendant in a capital case is warned by the judge for doing exactly what Goering was doing. And he said, "Judge, I'm on trial for my life. What are you going to do, take my driver's license?" You don't have total control over a Goering, but he hurts himself with that conduct. Jackson should not have lost his momentum. He shouldn't have gotten sidetracked. He shouldn't have gotten down and groveled with the witness. He should have just stormed on.
Justice Jackson did not have a law degree. He had gone to law school, Albany Law School. His father was a merchant. He didn't think much of lawyers, and he wouldn't contribute to his legal education, so he just studied for the bar, the way many did. But he had a reputation as being a terrific prosecutor, and that's why Roosevelt brought him into his Justice Department. Are you a little surprised to see what we're seeing?
Well, he's kind of saying this is a special case, and I'm on national TV, if there had been any TV, and I want special rules so this guy Goering doesn't insult me, because I can't imagine he thought the rule he wants was ever the rule. It's not in the United States. Judge Lawrence is giving the rule we have to live with.
Well, and it seemed to me that maybe Justice Jackson was being a little thin-skinned. You know, it's almost the old story of when you protesteth too much. I don't think anyone would have paid much attention to Goering's passing remark about the United States having secret war plans too. But when you make such a big point about it, all you do is you publicize that.
What he should have done when the answer was given, say, move to strike, and regardless of the ruling, gone on. Goering didn't help himself with that conduct.
Now, in the trials in the United States, it does seem that in many instances what a judge would say is, all right, if you ask the question which elicits just a yes or no answer, that's all he can say, and on redirect by his counsel, he can bring all of these extenuating circumstances out.
Well, that's a rule lawyers might like, but that's not the rule. The rule is if the question can be answered yes or no, you should give that answer. And then if an explanation is warranted, you're allowed to give it. Sometimes it isn't. If I say, is your name Fred Graham, and you say, yes, but I'd like to explain that, no, you shouldn't be permitted to. There's no explanation necessary. You're Fred Graham. Next question.
Now, based on what we've seen so far, has history given Robert Jackson a bum rap?
Well, there are two ways to look at that. Number one, he convicted the man on all 4 counts, and he died before he could be hung, so you could say he won the case. This particular segment doesn't hold Jackson up in a good light as a cross-examiner or as a lawyer with a thick skin. And if you don't have a thick skin, you don't belong in the courtroom in this country or in that courtroom.
Well, he had more recently been a judge. We're going to take a break right now, and when we return, Prosecutor Jackson continues to cross-examine Hermann Goering on his role in the Nazis' plan to exterminate the Jewish population. As Robert Jackson continues to plow through his cross-examination of Hermann Goering, the top Nazi leader on trial at Nuremberg, Goering continues to play word games with his cross-examiner. Next, Jackson asks Goering about how radical other Nazi leaders were when it came to what they called, quote, the Jewish question. Now, to these men, the word radical indicated a belief that Jews should die.
You have stated that on the Jewish question, some of the members of the government were more radical than you. And would you state who those were?
Zunächst war allgemein bei Regierungs...
Broadly speaking, when we took over the government, we only demanded their removal from political and other leading positions in the state.
Now, that isn't what I asked you.
The question was that you had said that some members of the government were more radical towards Jews than you were. And would you tell us which of the members of the government were more radical than you were? Verzeihung, ich hatte die Frage nicht verstanden.
Excuse me, I did not understand the question to mean who were more radical, but in what way they were more radical. If you ask who, then I would say that those were primarily Minister Goebbels and Himmler.
Then, it was you, was it not? who signed on the 31st day of July, 1941, a decree asking Himmler and the SS, the Chief of Security Police, and the SS Gruppenführer to make the plans for the complete solution of the Jewish question.
Nein, so ist das nicht richtig. Diesen Erlass
I asked to have you shown,
kenne ich genau.
I asked to have you shown document 710, United States 509. Give us your translation of it.
Darf ich es genau vorlesen, wie es hier steht?
May I read it as it is written here?
Der Ihnen bereits mit Erlass
Complementing the task which was conferred upon you already on 1/24/1939 to solve the Jewish problem by means of emigration and evacuation in the best possible way according to present conditions, I charge you herewith to make all necessary preparations as regards organizational, factual, and material matters. Now comes the decisive word which has been mistranslated. For a total solution, not for a final solution. For a total solution of the Jewish question within the area of German influence in Europe.
This letter itself was directed to the Chief of the Security Police and the Security Service and SS Gruppenführer Heydrich. We're right about that, aren't we?
Das ist richtig. Und
That is correct, but I have to make an explanation in connection with that.
All right.
die Erklärung abgeben, dass
The reason I sent this letter to him was that by the decree of 1/24/1939, Heydrich, or it may have been Himmler, had been given the task of dealing with the emigration of the Jews. Therefore, this was the government department concerned, and it was to the department which had been given the tasks that I had to apply concerning all material and economic matters arising therefrom.
And that is the conclusion of our coverage of Robert Jackson's, that is the American prosecutor's, cross-examination of Goering. Next, and we're going to take a break, and we'll come back to the British cross-examination. But I want to ask F. Lee Bailey, is there any difference in the tradition of cross-examination, or at least the style and technique between the two countries?
A marked difference. We have a few good cross-examiners in the United States. Most British barristers are good cross-examiners because they're trained and we're not.
Well, of course, the traditional British barrister probably tries more cases. They don't do anything but try cases. The solicitors do the office work. Is it simply that they get more experience?
No, I try as many cases as the lead barrister in England in the course of a year, and I also do the preparation or oversee it. But they have training. They have to go through the equivalent of an internship and a residency after they finish law school before they ever get to go to court, and that's all training of an apprentice nature.
Now, is there also a difference in that British judges tend to give the cross-examiner more leeway to use rough-and-tumble tactics?
No, I don't think that's true. British judges are fairly strict. On the other hand, they expect barristers to know the difference between a proper question and an improper question, and they don't interfere all that much, at least not the good ones.
Okay. Coming up, British prosecutor David Maxwell-Fyfe takes his turn at cross-examining Hermann Goering. And now, as we go to break, Chief British Prosecutor Sir Hartley Shawcross, back at that trial, gives his opinion that it was the British, not the American Robert Jackson, who had the prosecutorial flair.
He wasn't a strong prosecutor. His experience didn't lie on those lines. We had the people who'd brought up in the police court and used to prosecuting criminals.
British prosecutor Sir David Maxwell-Fyfe takes over the formidable assignment of cross-examining Hermann Goering. Maxwell-Fyfe begins with questions about an incident known as Stalag Luft III, in which 50 captured British airmen were shot by the Gestapo after escaping from a German prisoner of war camp. The incident had incensed the British public, and their prosecutors at Nuremberg.
Witness, do you remember telling me last night that the only prisoners of war handed over to the police were these guilty of crimes or misdemeanors?
So habe ich mich nicht ausgedrückt, sondern ich habe gesagt, wenn die Polizei...
I did not express myself that way. I said if the police apprehended prisoners of war, those who had committed a crime during the escape, as far as I know, were detained by the police and were not returned to the camp. To what extent the police kept prisoners of war without returning them to a camp, I was able to gather from interrogations and explanations here.
Now, the escape about which I'm asking you took place on the night of the 24th to the 25th of March. I want you to have that date in mind. The decision to murder these young officers must have been taken very quickly, because the first murder was actually took place on the 26th of March. You agree with that? It must have been taken quickly.
Ich nehme an, dass der Befehl, so wie ich später gehört habe, sofort...
I assume that this order, as I was informed later, was given immediately, but it had no connection with this document.
No, we're finished with that document now. We're going on to this, the murder of these young men. The a Großfahndung, a general hue and cry, I think would be the English translation, was also issued at once in order that these men should be arrested. Isn't that so?
Das ist richtig bei jedem Ausbruch.
That is correct. Whenever there was an escape and such a large number of prisoners escaped, automatically in the whole Reich a hue and cry was raised. That is, all authorities had to be on the lookout to recapture the prisoners.
So that in order to give this order to murder these men and for a Großfahndung, there must have been a meeting of Hitler, a Tenerate with Himmler or Kaltenbrunner, in order that that order would be put into effect. Is that so?
Das ist richtig.
That is correct.
I think you told the tribunal that right up to the end, your loyalty to the Führer was unshaken. Is that right?
Das ist richtig.
That is correct.
Do you still seek to justify and glorify Hitler after he had ordered the murder of these 50 young flying officers at Stalag Luft 3?
Ich habe weder den Führer Adolf Hitler zu rechtfertigen noch zu glorifizieren.
I am here neither to justify the Führer Adolf Hitler nor to glorify him. I am here only to emphasize that I remained faithful to him, for I believe in keeping one's oath not in good times only, but also in bad times when it is much more difficult. As to your reference to the 50 airmen, I never opposed the Führer so clearly and strongly as in this matter, and I gave him my views about it. After that, no conversation between the Führer and myself took place for months.
The Führer at Tenerate must have had full knowledge of what was happening with regard to concentration camps, the treatment of the Jews and the treatment of the people who were working, mustn't he?
Ich deutete vorhin an, dass es meine Meinung ist, dass der Führer über
I already mentioned it as my opinion that the Führer did not know about details in concentration camps, about atrocities as described here. As far as I know him, I do not believe he was informed. But insofar as
I'm not asking about details, I'm asking about the murder of 4 or 5 million people. Are you suggesting that nobody in power in Germany, except Himmler and perhaps Kaltenbrunner, knew about that?
Ich bin nach wie vor der Meinung,
I am still of the opinion that the Führer did not know about these figures.
Now, this is an interesting tactic. You see it very much in trials in which you have multiple defendants. And of course, Hitler was not a defendant here, but some of the others were mentioned. That is, in the cross-examination of one defendant, you're building a case against some of the others.
Except the ones he's naming are dead. He's laying the blame off on people that he doesn't have to torpedo to try and save himself. But, you know, Maxwell-Fyfe is doing a beautiful job. First, he's come right to the point. He's pinned him. He's got him to admit that he knew all about the decision to kill all the British airmen, and he opposed it and didn't speak to Hitler for months. It's like a petulant wife. And it puts him in a ludicrous position, and now he's got him nailed because he said, didn't you know about these millions of murders? And he said, I don't think we knew the figures. That's a pretty bad answer.
You know, the semantics of the questions, too, are quite effective. He calls him witness. That's not a very elevated way to be addressed. And then he says, these fine young officers who were murdered. Throughout his questions, you can see the very adroit use of loaded words.
Well, British barons in particular, but British people generally, still are able to master the language far better than their progeny in the colonies like you and I.
And I think that has something to do with the effectiveness. You know, they sometimes say that Southerners are men of words. They value the spoken word and the written word. Many writers are from the South, and you certainly true of the British, because they hold words and precise use of words in such high regard that it does permit them to be more effective in something like cross-examination.
One of the great stories that was made into a 6-hour TV special on ABC was QB7, the trial of the doctor from Treblinka, and the manner in which those British barristers handled the evidence was a sight to behold. I require my young lawyers to read British trials to learn the basics of cross-examination.
Well, is there any reason why, though, that American lawyers, even though they do not specialize quite as much as a barrister does, why they don't develop the same sort of skills, at least in cross-examination, which is a discrete form of what you do in a trial?
Well, a few do, Fred, but because they are untrained and unorganized, they have to kind of happen. They are not predictable. People teach themselves to cross-examine and often do that by not making mistakes twice. You're likely to make one the first time.
In your own experience, what is it that is the most commonly made mistake that you see getting you in the kind of trouble you need?
Not seeing far enough down the road. When you embark on a course, you may be driving yourself into the woods, and because the first couple of questions look pretty good, you get seduced into asking the third one, and that's the mistake.
It's when you get hoisted by your own petard.
Exactly.
We're going to take a break here, and when we come back, Roman Rudenko, the prosecutor for the Soviet Union, he takes his crack at cross-examining Hermann Goering. Coming up tomorrow, the head of the notorious Auschwitz death camp is called as a witness for the defense. And the admiral of the Nazi Navy defends his decision not to rescue the victims of sea warfare.
The powerful Anglo-American Air Force was patrolling everywhere and in increasingly large numbers. That was a point which caused me great concern.
All of that tomorrow on our look at the Nuremberg Trial. Roman Rudenko, chief prosecutor for the Soviet Union, is the next to cross-examine Hermann Goering. Now, despite Rudenko's relatively lack of familiarity with the Anglo-American practice of cross-examination, he fares better than the U.S. prosecutor Robert Jackson. Rudenko gets his questions in, and he manages to get brief answers to them.
If I understand you, Defendant Goering, you said that all the basic decisions concerning foreign, political, and military matters were taken by Hitler alone. Do I understand you rightly?
Jawohl.
Yes, certainly. After all, he was the Führer.
Следует ли понимать это так, что Гитлер принимал решение?
Am I to understand that Hitler took these decisions without listening to the opinions of the experts who studied the questions and the intelligence reports on those matters?
Das war verschieden. In einzelnen Fällen ließ sich selbstverständlich Unterlagen geben, ohne dass...
It depended upon the circumstances. In certain cases, he would ask for data to be submitted to him without the experts knowing the exact reason. In other cases, he would explain to his advisors that he intended to do and get from them the data and their opinion. Final decisions he took himself as Supreme Commander.
В таком случае, правильно ли я понимаю вас, что при решении серьезных вопросов...
In that case, do I understand you correctly when you say that when making important decisions, Hitler used the analysis and material given to him by his close collaborators, who advised him according to their specialty? Is that correct?
Given to him partly by his collaborators, partly, as in the case of communication and intelligence, by other members of the departments concerned.
Здесь, в судебном заседании, ваш свидетель Боденшафт...
On March 8th, here in the tribunal, your witness Bodenschatz stated that you told him in March of 1945 that many Jews were killed and that for that you will have to pay dearly. Do you remember this testimony of your witness?
An diese Aussage in dieser Form, wie sie mir eben...
This testimony, in the form in which it was translated now, I do not recollect at all. The witness Bodenschatz never said it that way. I asked that the record of the session be brought in.
А как говорил свидетель Боденшафт?
How did Bodenschatz say that? Do you remember?
Dass wenn wir den Krieg verlieren...
That if we lost the war, we would have to pay dearly.
Почему?
Why? For the murders which you had perpetrated?
Nein, ganz allgemein.
No, quite generally. And after all, we have experienced just that.
Now, Lee Bailey, it's rather impressive. They have no tradition of cross-examination. They beat it out of the defendant, confession generally under their system, so he said. And that was quite good.
Yeah, he's doing a pretty good job, but once again, this is really like shooting fish in a barrel. There has very seldom been anyone in a worse position to undergo cross-examination than Hermann Goering.
Now, interesting, Rudinko made his mark here. He was, many of the communists of that era, he was from a peasant family, had very little education. He went on to become their chief prosecutor, and he prosecuted Gary Powers. He was shot down in that U-2 flight over Russia. So he had quite a career after this.
I remember that case well for two very good reasons. Number one, I refused that job, and Gary Powers took it. And number two, Edward Bennett Williams told me he refused that case because there was no way to win it.
I would not have thought that it would have worked well. One of the things that Rudinko and the Russians did, it kind of sort of indication of the kind of justice they believe in, they kept insisting on cross-examining the Germans to try to prove that the Germans were guilty of murdering about 1,000, or perhaps more, a large number of Polish officers in the Caton Woods, they were called. Turns out later it's been proven now and admitted now that the Russians killed them. It was quite an embarrassment to the other prosecutors.
Well, that's probably so, but what better way to rid yourself of guilt than to pin someone else with it, particularly when his credibility is so far down, people may accept it.
Now, one of the things you see here is that in some ways, trials haven't changed much, have they?
I don't think they've changed a whole lot. I started watching trials very carefully less than 10 years because I was trying cases in 1954, and I hadn't been to law school or even to college. And things haven't changed a whole lot.
The cross-examination we saw, particularly by Fyfe, Maxwell-Fyfe, pretty much the way you'd see it.
It is more structured and more predictable. The Americans, the Russians, and so forth will vary more from lawyer to lawyer than the British will because they're trained.
What's the big change you see from, this is a 50-year-old trial. When you look at the American system now, many things are the same. What's different?
Well, first of all, trials have gotten longer. The fact that this could be accomplished for so many defendants for such horrendous sets of facts in 10 months is a modern miracle. They have trouble trying an organized crime case in federal court in New York in 10 months, and they have trouble trying anything in California in less than 16.
Well, you know, we've observed that on Court TV because we've seen so many California trials. We obtained an official report from the Center for State Courts, and they said that California trials are twice as long as they are in selected other states. Why is that? You were just there. You tried a long case there.
Well, first of all, we spent a lot of time wasting time there. The jury spent very little time in the courtroom listening to evidence, which was most unfortunate. Number two, California lets everything in, it seems to me, when they should narrow the trial down. The word relevance in California is a huge lake, and it should be a tiny pond.
Now, this trial that we've just observed, we've got a couple of minutes here. Really, it was quite a success, wasn't it? A lot of things could have gone wrong. Some things always do in a case. But a lot of things went right with this trial when you look at the objectives of the Allied side.
I think the only way to evaluate a trial like Nuremberg, which was a new idea in some respects, is historically. And I think that the people who organized it were winners. First of all, they were generally seen as having been fair to some very notorious and cruel defendants. They exposed the Holocaust in a way that might never have brought the truth home to the world at large. And I think the decent people of civilization have felt that the Nuremberg trials were a good idea and that benefits were obtained. That's the only measuring stick that counts.
Now, Justice Jackson was hoping to accomplish one further objective, and that is he was hoping that there would be a permanent war crimes tribunal that would flow from that. Didn't happen. I wish we had time to talk about it, but
well,
time is about
what this world needs more than anything else is an international criminal court with real jurisdiction at all times.
Didn't get it? Maybe we will thank you, F. Lee Bailey, for being with us yet again. And thank you for joining us as we begin the defense side of the Nazi war crimes at Nuremberg. Please do join us again tomorrow at 5 p.m. Eastern Time for our continuing look at the Nuremberg trial. You'll see other Nazi leaders as they presented their case years ago. We'll also be re-airing our entire 15-hour coverage of the Nuremberg trial this weekend, November the 18th and 19th. For now, stay tuned for Primetime Justice with anchor Terry Moran after these messages.